Great. Nice to meet you all. So my name is Vanessa Herzog. I work for a large company named Lee & Associates. They've just recently opened a Seattle office, but we're a nationwide company with 60 offices nationwide and over 900 brokers. The disciplines we cover are leasing, sales, investments, no business sales, property management, appraisal, valuation. So a full spectrum of everything that you'll find in commercial real estate. Commercial real estate is unique. We do not do any residential real estate. The only residential that people will do in commercial is they'll do apartment sales, investments of apartments, things like that. So, but no single family, and people generally don't cross over because the disciplines are quite different. So you guys all look a little bit older, so you've probably entered into a commercial, or not a commercial lease, but a residential lease, or maybe you've bought a home before. So you're somewhat familiar with the paperwork of that. Commercial leasing and purchase and sale agreements are quite different. They're structured completely different. And they, as Tom said, you don't want to just sign them without reviewing them, and you probably are going to want to have an attorney review them with you, because once you're in them, especially a lease. So what I thought I would do is, what I have in front of you is I have an example commercial purchase and sale agreement and a single tenant triple net lease agreement. And I thought what I would do is highlight on some of the areas that you want to pay close attention to, and take about 15-20 minutes to do that, and then open it up for questions, and then move into the second document. So they're pretty long. So what I've done, we'll start with the purchase and sale agreement. I highlighted in yellow the areas that I thought we should touch on, that are places you're going to want to pay close attention to. Your commercial broker, well, let me just back up. This document, you'll see each one of these has a logo on the upper left right-hand corner called CEBA. That's the Commercial Brokers Association of Washington State. And they got together with a group of attorneys, and they created standard documents, so that if you don't have an attorney drafting your own individual documents, which you'll run into that, you'll run into, especially landlords, they'll have their own lease agreement, and that's what they'll use. But if you don't, this is a very good agreement to use both for purchase and sale or lease. It's a legal document. It's basically fill in the blanks, but you need to know how to fill in the blanks. So most brokers, commercial brokers working in the state of Washington, are very familiar with these documents. I would say probably 70% of the transactions happen on these documents right here. So there are these forms out there available for you to use in case you run into a landlord, and this happens very rarely, but once in a while, where the landlord has a one-page lease or he has no lease, and you want to have a little more protection than that. So we'll start with the purchase and sale. On the, these, where I've highlighted are things that are different from a, yes?
Sorry, are we giving these back to you?
No,
Okay.
these are for you.
Okay.
What I've highlighted are things that are different that you need to pay attention to. So when you buy a house, you've got still a lengthy contract, and a lot of the things that you'll see in here are the same as buying a home. But I've highlighted the things that are different or important. The first one is the reference date. And the reason I highlighted it is because the reference date is the date that you refer to the contract as, like the formation date of the contract. This date can change, but sometimes it doesn't change, and it'll be different from your mutual acceptance date. So when you work with a document like this, you just have to know that this line at the top, the reference date, is just the date referencing the contract, not the date that you actually go under contract. And that can be confusing. The buyer and the seller I highlighted because you have to have your buyer and seller legal names absolutely correct. So when you are looking at buying a piece of property, you want to make sure that you have the correct seller name in there, and your broker can do that. And I will tell you, in 31 years of doing business, I still see these forms incorrectly filled out, even if it's coming from an experienced professional commercial broker. And I don't know if it's just because they don't know, they don't do the research or whatever, but if the name of the seller and the buyer aren't correct, it could be an invalid contract. So you want to be very careful what you do. The way to find out and make sure that your seller name is correct is you can get on the county assessor's office, look up the property, and see who truly owns it, right? So that's one way for you to double check if your broker doesn't know. Your broker should be able to help you. The second thing that I've highlighted is your legal description. If your legal description isn't attached, you do not have a valid contract. Now, where do we get the legal description from? You cannot go to the assessor's office and pull down the abbreviated legal and call that correct. That is not going to fly. You have to go to a title company and ask them to pull you the last deed. Okay? And the reason why that's important is because if somebody wanted to invalidate this, the first thing that they're going to do is they're going to look and see if the legal description attached is correct and if it's correctly identifying the property that you're buying. If it's not, your contract's invalid. So I still see a lot of brokers attach an abbreviated legal that they pull down off of the assessor's office, online information, and I always replace it. So I'll go to the title company and say, I'm buying, we're working on this piece of property. I need a last deed for a purchase and sale agreement. They'll send it to you. So the next thing you look at in a purchase and sale agreement on a commercial side is the purchase price, but more importantly, the way in which you're going to purchase. Now, when you're buying a home, generally you're pre-qualified, you write the purchase and sale agreement, your earnest money almost immediately goes non-refundable when you're buying a home. That is not the case in a purchase and sale of a commercial property. And the reason why is there's different ways to purchase. Generally, you're going to have a financing contingency. You're going to have the opportunity to check out the property. You're going to do a phase 1 environmental. You might do a survey. You might do a structural inspection. All of those things will get done before your earnest money goes non-refundable. So in this section here, what you look at is what this is talking about is when your earnest money is going to go non-refundable. Usually you deposit the cash with the escrow company, but it stays refundable until you waive your contingencies, however long that is. Most of the time when you're buying an existing building, it's 60 to 90 days. It can be a much longer time than that if you're buying a piece of land and building a building. So in
Standard for earnest money.
earnest money, it's all over the board. Most sellers want to see that you've got the cash earnest money. They don't want a promissory note. They want the cash to be in escrow so that they know that you've got cash and you've been willing to put that up. It's still refundable, so you will get it back, but they want to see the cash rather than a promissory note, especially if you're buying a building and it's just a matter of you getting your commercial financing together. They want to know that you've got the wherewithal to do that. So the standard, the maximum is generally 5%, but if you're buying $1 million building and your earnest money is $25,000, that's a respectable deal, right there. So I would say that small earnest money is less than $10,000. People that own commercial properties begin to wonder if you've got the wherewithal to take it the rest of the way. So, and your earnest monies are applicable to your purchase price. So it's all rolls in. If you waive your contingencies and move forward towards closing, that earnest money is rolled into your down payment. Okay. The next section is the exhibits and addenda. I highlighted this because with this document especially, all of the exhibits need to be additional documents attached. So it can make this document kind of long, but they all address specific things. The legal description is on its own exhibit. Utility charges addendum, why would you put this in there? If you're buying a building, for instance, you want to make sure you know what utility accounts are there, and you want to have those transferred at closing, just exactly like when you're buying a house, so that the seller doesn't end up getting a bill later down the road, and then you have to pay them, and then you have to argue about it. And then the seller form 17, much like residential, commercial sellers now have to give a disclosure form. You have the right to waive that if you want to as a buyer. It's just another thing you attach to this. Sometimes the sellers will fill it out. They actually have to fill it out prior to you closing. So that's something that even though they don't list it here, I wrote it in handwritten form, so you know that that's something that before closing has to be delivered to you. Section 4, seller's underlying financing. You might wonder why this is in there. This is something that was added after 2008 because people were over-leveraged and they couldn't pay off their debt at closing because they were selling the property for less than what the debt was. And so in this section, this deals with, it's still, we don't see it very often anymore, but in 2008, 9, 10, there was a lot of instances where it was a bit of a short sale and you had to protect the buyer. Then we get to feasibility. Feasibility is a very important part of a commercial purchase. And during your feasibility, you'll put the property under contract and then the clock will start running on your feasibility. The feasibility is there for you to investigate the property and become satisfied with it for any reason whatsoever. You can walk away for any reason whatsoever during this time. Your earnest money might be in escrow in a cash form, but until you waive this contingency, your earnest money is still refundable. Right? So a lot of times what people do, and it's really important if you're buying a commercial building, you want to do a phase 1 environmental report. This will cost you about $2,500. The report will give you a historical use of the building, anything around the area that has contamination, anything that you should be alerted to within the building that might cause contamination. It's probably the single most important thing you need to do on a building or any property. The reason why is once you take title, if there's a problem, it's your problem. The other seller's gone, Department of Ecology doesn't care. They're looking at the current owner and you don't want to have to clean up what could potentially be a really bad mess. You know, the typical things that we see are asbestos in the building, in lighting, insulation, floor tiles, lead paint. Not as big a problem, but it's there. Buried oil tanks. You know, you will have, especially in an older building, you can find contamination that transferred from one property to the next. So maybe your property didn't cause it, but it still is affected by it because the groundwater movement underneath the ground, or just leakage through the soil. So there's all of those things get identified. In a phase 1, your phase 1 report will go back historically and look through the life of that building and the life of that property, and you'll get a report that shows you everything that ever happened on that property and then some of the neighboring properties. So it's a very, very good investment. You also learn a lot about your property and what it was used for. So if you get your phase 1 back, and you decide there's something wrong with it, at that point you go to the seller and you say, look, there's a buried oil tank and it's been leaking or whatever's happening on the property, and you go back and then you renegotiate how that's gonna work out. If the seller says, I'm not gonna clean it up, you take it on and you decide, I don't wanna take it on, that's when you terminate the purchase and sale agreement and you say, I'm not waiving the contingency. Feasibility, I want my earnest money back, I'm moving on, you're free to go. So the feasibility section also allows you to do things like a property survey. If you are buying a property for an investment, it gives you the opportunity to look at all the leases, confirm that the leases are correct, what the lease payments are, if the income's in place, just like it's been represented to you. So the feasibility is like this huge catch-all time period during which you can do whatever investigation you want to do and confirm everything that you need to confirm to your satisfaction. So there's one other contingency that you will have in a typical purchase and sale agreement, and that's your financing contingency. Generally what happens is the feasibility and the financing contingency run concurrently. So, and they generally, a financing contingency will take you about 90 days to get through. So a lot of times what we see on a purchase and sale agreement is we will see the feasibility contingency and the financing contingency both running the same time frame. They'll both be 90 days. Maybe they'll have an extension on top of that, but they'll run consistent or concurrently together, and they'll be the same time frame generally. Sometimes a seller will come back and say, hey, do your physical inspection first, waive that, and then I'll give you more time for your financing contingency. That's very common, but generally 60, 90 days for both of those is a typical period when you should be able to get through the process. So that is very different from buying a home, because in a home you don't really get this. You have to know that you're going to buy that pretty darn quick. So, and I think that's what your home inspection's for and why they do them up front and give them to you when you're buying a home. If you notice in this section, there's also some time frames. There's a time frame for when the seller has to deliver books and records on the property to you. So on this, the standard is 2 days. A lot of times we do this within 5 to 7 days. Sometimes the seller doesn't know what they have, and so it's important for your broker to ask the seller's broker, maybe get that to me ahead of time so I can take a look at it. On access, this is as a buyer, this is your access to the property. So if, for instance, you want to go on the property and let's say that you want to have an engineer go in and do a structural report, this gives you the ability to access that. When you're doing a phase 1 environmental, they'll have to get on the property. They may want to take some soil samples. This section gives you the ability to have access to the property. Now, if you do anything to the property, you have to return it to its condition, even if you don't buy it, especially if you don't buy it. So that's what this access is about. This isn't for the seller's access, it's for the buyer's access. Then we get to a very complicated part, the title insurance. So title insurance, on a lot of properties, you might do a standard policy, you might do an extended policy. But the title insurance is pretty important with regards to buying a property. And how many of you guys own a home? So you know what your title looks like, and there's encumbrances on titles. So for instance, on this building that we're in right here, if I were to buy this building, I'd look at the title and I'd want to see, first of all, does the legal description attached to this purchase and sale agreement match the legal description that the title insurance company is going to insure? So title insurance is an insurance policy, and it is underwritten by people with a lot of money, so that if you buy this property and you find something that's different than what's in your title insurance policy, then you've got a claim to go back. So this is an area that you need to pay close attention to. Might want to have an attorney help you through this section of this. But there are some timelines, which I've highlighted in permitted exceptions. So what happens is you will get a preliminary title commitment, and that should be delivered to you within 4 or 5 days of the property going under contract. And it'll be from one of the major title companies, Chicago, First American, Ticor Title. And what you want to look for in a title company is you want to make sure that they've got enough money to cover any potential claims, because it's just like buying car insurance. You're just buying it for your property, right? So if you buy a building like this, and let's say you want to redevelop it, but there's an easement going through the middle of it that doesn't allow you to redevelop it, but you didn't know that prior to closing, now you have a building you can't use, you want to make sure you've got a title company that can cover that defect in the title. So I don't want to go too much into title because it can get really complicated, but it's an area that's important. In your purchase and sale agreement, what I've highlighted are these timelines. So what happens, and a lot of brokers miss this, and a lot of brokers, when I highlight this and say, here's your critical dates that we have to meet, they go like, oh, title, a lot of people don't pay attention to it, but it's very important, because if you don't meet the timelines in your purchase and sale agreement, you can inadvertently terminate your purchase and sale agreement just because you missed a timeline. So those are important things to pay attention to. The difference between standard title and extended title: standard just finds things that are recorded on title or that are physically obvious. If you want an extended title, and you generally would do this if you're in a very complex inner city area, or you're buying a big piece of land, or you're buying a property that's, maybe has some unclear boundaries, it does require you to have a property survey, and it's a different level of survey. It's an ALTA, which is an American Land Title Association survey. And what that does for the property is it not only identifies the boundaries and everything that's on the property, but it brings forward any unrecorded claims. So that could be a leasehold, it could be an easement, it could be a mechanic's lien, those things that maybe necessarily haven't been recorded on title that might show up later. So it costs a little bit more. Your policy will be more expensive, and then you'll have to do a survey, which could be a couple $1,000s. Depending on the type of property that you're buying, it might be well worth it for you to invest in that. But that's the difference between standard and extended. Generally, the purchaser pays the upcharge for that. If we go further through this, I highlighted this unpaid utilities charges. This is just a note that you can have escrow take care of making sure all the utility charges are wrapped up during escrow and closing, so that you don't have to go out and read the meter and you don't have to do all of that. It costs about $30 or $40, well worth it. Have them do that work. The other section in here that's important to a buyer is the seller's representations. In this section, the seller gives what they call representations and warranties to the buyer. Things like they actually own the property and they have the authority to sign the purchase and sale agreement. That's probably pretty important, so you're not giving your money to somebody that doesn't really own the property. They're warranting here that they haven't done anything to contaminate the property, that all the books and records that they give you are accurate and the best of their knowledge and everything that they have. So this is a section that just read through it at your convenience. This protects the buyer quite a bit. But you should know what's in here because it'll also raise questions for you on maybe things you want to check out during your feasibility period. There's another interesting section called as is. So in a commercial property, you basically are buying the property as is. There's really, after you get through your feasibility and you have these reps and warranties in here, if you still close on it, generally you're not going to be able to go back to that seller with many complaints. Now, do people do that? Yes, they do it. But a lot of times the as is section holds up. So you want to be very careful during your feasibility period to make sure you check out everything you can possibly think of, because once you buy it, it's yours. FERPTA. This is an interesting section. You'll see this in here and you'll say, what is this? It has nothing to do with anything unless you are a foreign person buying an American piece of property, right? So this has to deal with if you're coming over from China and you're buying a piece of property and you're not a US citizen, that's what this addresses. If you're a US citizen and you're buying a piece of property, this doesn't apply to you. What happens with a buyer and a seller who are not US citizens is they pay a different tax rate. So if you are, let's say, a Chinese national and you're selling a piece of property here, your tax that you pay to the government can be about 30% of your excise. It's not like an excise tax. So anyway, yeah, they ding them pretty hard. Assignment. A lot of times the buyer will buy a piece of property and then they'll want to assign it to something else. Most of the time, they're forming an LLC for their company or their, and they'll just throw it into an LLC instead of owning it in their own personal name. Very, very common. I would say 100% of the transactions I do are done that way. What the sellers don't want, and the sellers are fine with that. So, that's sort of a common pass-through, and the sellers don't really have a problem with that. What we find is when you just give a blanket assignment is you could tie this property up and then you could flip it to me and you could charge me more money for that. And that's what the sellers really don't want to see. And that's what this assignment section is all about. And when you're in an upmarket like we are now, that can happen. So the sellers, as you can imagine, don't like that. So this gives the sellers the ability to say, look, you can assign it to your LLC, that's fine with me, but if you think you're going to tie it up and flip it and make some money, no, you're not going to do that. The rest of this is pretty standard stuff. I attached at the back of this all the exhibits that we talked about, so you can see where the legal description goes. If you have changes or different things you want to talk about in the purchase and sale agreement, this is an amendment, addendum. This will change language within your purchase and sale agreement, or it'll add terms and conditions. This needs to be generally written and reviewed by an attorney. So when you're going through this kind of process, I would have an attorney who can review this language for you. A lot of brokers will write language in here. You just want to make sure that the language is sufficient to legally cover you in the event you get down the road and there's not quite a meeting of the minds. This is a promissory note. So if you do decide to use an earnest money promissory note, this is what they look like. And there is one thing to remember about this is this is legal tender if you sign this. So don't let that original out of your hands. This should always go to the escrow company, and you should never give it to anybody else. And if you make a copy of it, you should write copy all over it so that somebody doesn't come back and say, well, here's your promissory note, you owe me this money. Especially in the day of electronic documents, you want to be really careful that that original is what they call a wet ink original. We generally sign it in a blue pen. I still do that. I learned that years and years and years ago, and I still do that because there's no doubt that is your original, plus you can feel it on the paper. This is a financing addendum. This shows you what you're going to need to do, or how much time you're going to need to have to get your financing done. Generally, when you approach a seller to buy a piece of property and you've got a financing contingency in there, they will ask you for a reference from your lender. If you're pre-qualified, are you qualified? Do you have the funds for the down payment? That leads us into an interesting topic. How much down payment does a commercial building usually require? If you're buying a building for your own business, you can go through a small business administration. Your down payment can be as low as 10%. If you are buying a building as a partial investment or 100% investment, maybe you're only going to occupy 25% of it, you'll go through a commercial standard loan. Your down payment will be anywhere between 15 to 30%. Most sellers will want to see that you have that down payment. So if they ask you, if their broker says, hey, provide proof of funds, that's a really standard question. The utility charges addendum, this is what it looks like. The seller and the seller's broker should fill this out for you and tell you all of the utility accounts that they have. You should not have to go and look for those. And then escrow takes this information and they close out the accounts at closing. This is the disclosure form, just so you're familiar with those kinds of things that you can ask the seller to disclose to you. When I take a listing, I usually have my sellers fill this out so we've got it ready to go by the time we have a purchase and sale agreement. If there's anything in here the seller doesn't understand, doesn't want to answer, can't answer, at least as their listing broker, I talk about it with them ahead of time so that we have answers for the buyer when they come forward with an offer. This has to be filled out or it has to be legally waived before you close. If you don't receive this, you can choose not to close, even if you've waived all of your contingencies. So this is very important for them to give to you. So that is the purchase and sale agreement in a very quick run through. So do you have any questions or anything about this document?
I have one question. So you said the 10%, is that out of the person's own money, or is that from the financing that they're receiving from?
That's your own cash. And it'll be referred to as equity. Now, somewhere that's going to come to you, and it's going to be cash, like a down payment. Whether you borrow it, whether you take it out of your 401k, wherever it comes from, it's cash. Yeah.
You said that the CBA was Washington-based. Does it change state to state?
It will change state to state. Real estate laws are different. I mean, they're very similar, but they're slightly different in each state. So this is just Washington. And they've got a website you can get online and you can take a look at the documents there. They do a really good job. And I think that these are more slanted towards the buyer and the tenant. Some leases I've seen and some purchase and sale agreements I've seen are very, very slanted towards the seller. So I think this is a really good document to start with. Yeah. Okay. So with that, let's move on to the lease agreement. Now, the lease agreement, leases are quite different. Commercial leases are different from residential leases in a couple of ways. If I were to buy an apartment building, and let's say I wanted to live in one of those units, I could just give notice to that tenant, and that tenant would have to move out because I own that and I personally want to move into it. And I would have to give them 30 days notice and they would have to be gone. On a commercial lease, this is not the case. When you sign a commercial lease, one of the reasons it's notarized, and the only reason it's notarized, is because you're actually taking an interest in that property. So the seller cannot sell the property to somebody who wants to use it and just terminate your lease. And the reason is because you've got a business in there, and it's very, very hard to move a business once you're in.
Could you, like, if I did that, if I had a lease with somebody and we both wanted to get out, could we both get out, or is it just like a...
You can terminate by mutual acceptance. You can, by mutual consent, but I don't see that happen very often. And the reason why, really, in the years of, I never understood this at the beginning of my leasing career, but the reason why is it's very hard and it's very expensive for a business to set up in a building. You have all sorts of hidden costs that when you go to move, you're going to pay again. Reconnecting to utilities, setting up your data, setting up your security system, setting up your phone system, all of that, moving your equipment, very, very expensive. So that's why the landlords can't just, and the tenants just can't move out. So this is a very strong binding agreement. Usually we start with a letter of intent, and that's what this first document is. And this is a very condensed form of which you can propose to a landlord the terms and conditions that you want to lease the space on. So you don't need to get into a 40-page document. You don't need to fill that all out, because on a lease you're going to want to have an attorney help you. That'll cost you money. This is a really simple form that you can use to submit to a landlord to say, hey, here's how long I want to lease, here's what I want to pay, here's what I want you to do to the building, here's what I want to do to the building. All of those basic things are covered in a letter of intent. This is how I would say 100% of my leases are done. We start with the form, no matter how large the company, how complex the deal. Sometimes these can be quite long because there's certain things that a more sophisticated situation will address. But if you just want to go out and lease shop space, this is probably a sufficient document in its exact form here. Some of the things it touches on are premises, square footage, lease commencement term. Now, lease commencement term and rent commencement can be different. So you may move into the space, but you may negotiate that you want a couple months for free. So your rent commencement is going to be a different date than your lease commencement. Lease commencement is the date that you want to pay attention to, because that's when you actually take possession of that space, right? Security deposits are different in commercial leases. They are not held in a trust account. They can be commingled. A lot of times the security deposit is something you may or may not get back. So it's a very different, you need to pay attention to how you want to deal with your security deposit. Permitted use is very important, because if you want to lay out exactly what you want to do in the building, if the landlord comes along and you're doing something completely different than what you told him you were going to do, he can terminate your lease. So this is something you want to tell him up front. The other thing is you want to make sure that before you look at a space and go to the trouble to even fill out this paperwork, you want to make sure that you're compliant with zoning. So you might want to go to the jurisdiction, talk to the planning department, tell them where you want to move, and then say, hey, here's what I want to do there, can I do it? And they'll tell you yes or no. Tenant improvements, basically what are you going to do to the building? Tenant improvements are different from landlord improvements. You may say, landlord, I want to lease the building, but I want you to upgrade the lighting, or I want you to paint the inside. So in here, a lot of times what we'll add under tenant improvements, we will add a section called landlord improvements. So it's clear who's paying for that. And you want to state in this section who's paying for that. Because the landlord may say, well, great, tenant, you can go do that all you want to, have fun, get a permit. And you may have thought that you wanted him to pay for it, but he may not know that. So you need to say in these sections who's paying for what. Brokerage commission, your broker will fill that out. Generally, the landlord's paying a 5% fee, and that's paid by the landlord. In very rare instances will the tenant pay the commission, and that's when you're basically competing for a space. That might happen up in very, very tight markets like Seattle or Bellevue right now. It is not happening here. Exclusive negotiations. This section rarely is used. What this is asking the landlord to do is, while I'm negotiating with you, I don't want you to show your space to anybody else. Most landlords will not agree to that, because why should they? This is just a non-binding letter of intent. But some people ask for it, and sometimes it happens. Binding agreement, a lot of times a letter of intent is non-binding because this is your lease. There's so much more to negotiate. And so you can ask for this, but you generally won't get an agreement to that, because you're just kind of all moving forward on good faith at this point. But most landlords, when they get a letter of intent, they'll take it serious, and if the tenant's qualified, they'll move forward and they'll be good to their word, is mostly what I see. So it's a pretty short document. You do want to have this signed when you get to your final agreement on all your terms and conditions. You do want to have it signed. You want to execute it yourself. You want to get your landlord to sign it. That way, if you ever go back, because this can go through 4 or 5 or 6 iterations, if you ever go back, you can see what was finally agreed to. And sometimes that is very important when you finally get into the lease document. Sometimes you need to go back and remember, what did we really agree to? Because a lot of time can pass. Between the first letter of intent and a final letter of intent, sometimes that can be 2 or 3 weeks. By the time you get through your lease, you could have been negotiating for 30 to 45 days. So you can see how your memory sometimes can be, you can kind of forget. In the lease document, again, at the top, you want to make sure you've got the legal entity. The landlord is going to be very interested in who is really signing this lease. Is it you or is it your company? The reason why is because the leases are going to be guaranteed, either a corporate guarantee or a personal guarantee, and both of those are very strong guarantees that you give. If you default on a lease and you've given a personal guarantee, the landlord, if he wanted to, could come after you for everything that you own. Your house, your car, your cash, everything. So these are not documents to be taken lightly, and a guarantee is not something to be given lightly. So he's going to want to make sure that he knows who he's doing business with, and you're going to want to make sure that you know who you're doing business with.
Is that normal to have guarantees?
Absolutely.
Always?
Always.
Like a bank, okay.
Because you're taking their real estate, right? You've got control of that real estate, and once you're in there, you're in there. And if you default on a lease, a lot of times there's remedies for just a pure financial default. So what'll happen is, let's say halfway through your lease, you're just not making it, and you go to the landlord, I've got to get out of here. The landlord will say, why don't you try and sublease your space? The landlord will say, okay, well, let's put the space on the market. They'll try and help you find another tenant. Some landlords aren't that nice. Some will say, we don't care. You owe us some money, write us a check for the entire balance of that lease, and then we'll let you out. So you have to be really careful when you negotiate these. Again, a lease requires a correct legal description. Just recently, there was a landlord that, I don't know how this happened to him, but he leased his space to 2 tenants. And one of the leases didn't have a legal description on it, and the landlord and the attorney for the landlord were able to terminate that lease because it didn't have a proper legal description. That tenant had nowhere to go, but they were out of luck because they didn't have a legal description. Very simple. So pay attention to it. I can't tell you how many times I get a lease from a experienced broker and there's not a proper legal description. It's like a complete rookie mistake. So you pay attention to it as a tenant, because if you're competing for a space, you could lose out on that. There's a couple different ways that lease rent is paid. Base rent, what I've given to you is what I call a triple net lease. So there's different ways to lease. You can do a gross lease, which means that here's your total rent. It includes everything, utilities, everything. This is your total bottom dollar. That's all you'll pay. And then you've got something that's a little different than that. It's called a modified gross. And generally what that means is the landlord is paying some of the expenses and you're paying some of the expenses. And they should, on the lease, list out for you what those expenses are so you can actually get to that gross number by adding all those numbers together. And then there's a much more standard lease. It's called a triple net lease. The triple net lease, you've got a base rent, which is the rent for the actual physical space that you're renting, and they usually call that the shell or the base rent. And then you will reimburse the landlord for additional cost. You will pay him your fair share or pro rata share of property taxes, his fire insurance, property management, maintenance of the building, landscaping, whatever else he rolls into those expenses that he's passing on through to you. In this community, in a typical office building, that'll add maybe $5 per square foot per year to your rent. In a warehouse building, it'll add $1.50 to $2 per square foot per year to your rent that you're already paying. So those are the differences. It can be a little confusing, but once you start to look at it, you'll be able to get to a gross number. The listing agent should be able to provide to you or to your broker exactly what those additional expenses are.
Are the triple net negotiable?
Yes, but they aren't done very often.
Why not?
Because the landlord, most of the costs are costs that the landlord cannot control, like taxes and insurance. I would say 75% of your triple net costs are taxes and insurance. And the landlord can't control that. So what you're paying in addition to rent is you're paying part of that landlord's carrying cost of property taxes. Now, do you get a better deal on a gross lease? Not necessarily. The landlord takes the risk in, let's say the taxes go up sky high one year and he hasn't covered himself for that, then he's taken it in the shorts. But generally what they do is they add in all of their costs and then they bump it up a little bit just in case that's going to happen. And generally you won't get a long-term lease on a gross lease because the landlord doesn't know what's going to happen. So maybe you do that year to year. I don't find very many landlords doing gross leases anymore. However, what's very interesting is one of the largest property owners, commercial property owners in the country, a company called Prologis. They are now going to what we consider to be a modified gross lease. So what they found is that it was more cost effective for them as a company to do a modified gross lease and just pass the real estate taxes through to the tenant. And what that saved them on the backside for themselves was a lot of negotiations over what they call an operating cost would be, a lot of the reconciliation at the end of the year, a lot of the legal cost involved and the accounting costs involved with them reconciling those costs at the end of the year for each of the tenants. So it'll be interesting to see how that works for them. They just did that this year. So anyway.
Are you gonna cover the CPI?
Yep, we can. So there's three different ways to rent. If you're doing a triple net, you will use the base rent. And that will be your base rent just for your physical rent. And then there'll be a schedule on the back that should show you what your triple net costs are. So when people say it's $5 a square foot triple net, you know that there's another pretty good sized number out there that's going to be part of what you pay every month. Okay, so as we go through this, a lot of this stuff is really basic. I highlighted for you what a triple net lease is, so you can read through that. On the next page, the uses. Again, this tells you what you're telling that landlord you're going to use it for, and if you use it for something different, he could get upset and terminate your lease. Compliance with laws. One of the best situations I can tell you is when marijuana became legal in this state. You know, there's some landlords that would do that and some that wouldn't. What all landlords can require you as a tenant to do, unless they agree to it ahead of time, is that you have to have a legal use in the building. If you're doing something illegal, they can terminate your lease.
Can we touch on that a little bit, the
Yeah.
marijuana?
Marijuana? Mm-hmm.
A lot, because it's not federally recognized,
Right.
right?
Mm-hmm.
But a lot of times, landlords are willing to have the shop owner in there, because if I understand it correctly, if the federal government come in and basically shut you down and take the building, correct, away from the landlord.
Mm-hmm.
But how likely is that, though?
Well, I've done a lot of those leases and property sales, and so it's kind of a risky area, and we dug into it a lot. I had one landlord, and his buildings were in an area where you could do marijuana processing. So there's two different kinds. There's processing and then there's retail, right? So generally what I've done is the processing. They're larger leases. It's in the industrial areas. They've got setbacks. So he was very concerned about this, and there was a couple things that he needed to be very concerned about. Was one, the tenant going in there and operating illegally under the laws of the state of Washington, even though federally it's still illegal. Money laundering was a concern. So when you were taking that rent from them, you didn't want to take any cash. And just basically what happens if they go out of business and then you're a landlord with a bunch of marijuana plants in your building, what do you do? So these are some of the concerns. So we worked through it with several different attorneys to figure out a special addendum that attached to the lease that dealt with all of those situations. In the situation of the feds coming in and just taking your building, you have time as a landlord to cure that. And so in the addendum, what we put in there was if the feds come in and decide that they're going to shut all these things down, the landlord had the ability to go in and remove that tenant and get them out of the building so they didn't lose their building. It was a gray area. There's still risk with it, but we did the best we could with it. So it's been very interesting.
It's popping up. There's all restaurants, more cannabis shops than restaurants.
I know, it's been very interesting. I was just at a real estate conference where other brokers from around the country were talking about, how do we deal with this? Because Washington and Colorado were the two first states to make it recreational. And then I think it was Alaska, Oregon, California, Delaware. And I think there's 15 or 16 more states coming online with it. So it's still kind of a phenomenal, weird area for leasing. And there's certain landlords that just can't deal with it. Anybody who has a loan on their building might not want to do it because if the lender decided to object, they could call their loan and they'd have to pay it off, right? So the landlords that I worked with basically owned their properties almost free and clear. So they could either pay it off or they owned it free and clear so they didn't have to deal with that. Anybody who's institutional investor dealing with any kind of pension fund or federally regulated money couldn't touch those users at all because they would be violating, because they operate on a federal level. Title companies now will not do title insurance or escrow for a 502 use. They won't touch it for a building that has a tenant like that in it that the landlord wants to sell, and they won't do escrow or title for somebody buying a building with that as their intended use. So the feds have, under this jurisdiction or under this government that we have now, they've kind of, I think they would like to really tighten up on it. And so we're starting to see that. The actions coming down through the title company were just announced like a month ago. So, that's got to be coming down from the federal level, and you're just going to have to work around it.
So how do you get a building then?
You pay cash.
Well, let's set it up. Jessica wants, she wants to get into the cannabis business. Retail or processing? Retail. Retail. So she's trying to, basically, I guess she wants to do it, but she wants to know how do you talk to a landlord to say, hey, this is okay.
Well, generally, if you want to do that, there's some brokers out there that have done that. I don't do any retail, but I know a guy that does retail. They know which landlords will and won't do it. And you can just tell if it's what we call an institutional owner, they're not going to do it. They just can't, no matter how much money you offer them. So you've got to go to a privately owned building, and then you have to be within the area that it's allowed to be in. Generally, what we did with the tenants that we were working with, they operated on a cash basis. So when they came to us, we treated them like a startup because whether they had a lot of money or not, they didn't have established banking relationships. So they didn't really have any strong financials to give to us. They just had a lot of cash. So we did, on the buildings that we leased, we required 6 months to 1 year of upfront security deposit in case they left. All the tenant improvements they did on their own. What else did we require? It wasn't really strict. It was actually pretty simple. We didn't want to be paid in cash. They had to find a way to give us legal tender. So if they had to go to the bank and get a bunch of cashier's checks, that's what they had to do, because we weren't taking their cash. So I can't think of what else we did, but those are some of the critical points. Building insurance for processing was a little bit different because nobody knew if it was highly flammable or not. So the excess cost in building insurance, fire insurance the landlord had to carry got pushed out to that tenant. Now, I don't know what it would be on retail. Maybe it's extra security. I don't know.
But what if you want to buy the building?
You have to buy it as you, and then what you do with it after that is your business.
So the title company.
They might sell you a building, you as
Me. Oh, okay.
you individually.
Okay. I got you. Okay.
Yeah. But if you have a business that's XYZ marijuana retail,
Yeah.
they're not going to sell a building to XYZ. I mean, you can buy it, they just won't give you insurance, and they won't handle your escrow. So what people do generally is they buy it in their own name. They don't buy it in the company name. And usually what you'll do is you'll put that property into an LLC, and then you'll lease it back to your company. That's what you'll do.
So do you see this industry kind of fading away, or is it still kind of?
I see it very stabilized. When it first became legal, there was a huge amount of request for properties, and everybody and their brother was going to go and do this business. It's really kind of shaken out now, and it's stabilized. And I think the product pricing has stabilized because nobody really knew how much volume or demand there was going to be. And I think that is all getting really stabilized now. So I think the people that, the state was requiring medical growers to go under the fold. And so that's all done. So everybody's under the same licensing now. And I think the state and everybody else is starting to get used to how the business is working. I don't know that anybody's really banking these businesses. So I don't know how, I don't know how they're paying their taxes or anything yet like that. I don't know how that's done. As a landlord, we don't worry about it.
Yeah, they put it all in like big safes in their home.
That might be true.
No,
Yeah.
I know. I've seen all this money.
Yeah, and I don't know how they're paying their taxes. They're just hauling a bunch of cash down to the state, and then all of a sudden the state's laundering money. So it's kind of a weird conundrum, right?
Yeah, and it's true too, because from a federal standpoint, because the banks are FDIC insured, which is a federal
Right.
insurance. However, the state requires that, they have different national banks that come in to bid for be their primary bank. So Wells Fargo can be a bank for the state for 2 years. The Bank of America can be the bank for the next 2 years. And what happens is that it's almost like the state is really money laundering because they
Yeah.
want the tax dollar, but they deposit it to Key Bank or Bank of America, and they use it. But that's okay?
I know, right? So it's a very, it's not quite a settled situation yet, but it's, I think it's a good business. And if you just look at it as a pure business, I think it's beneficial business both to the people running the businesses and to the state. So they'll figure it out. There are some banks I heard that are lending to those businesses, and I think it's Kitsap Federal Credit Union, and there's one other one whose name I forget. But a lot of those, when you go to lease for that use, you just need to have a lot of capital with you, which means you might need a partner. If you don't have the capital. So when we were doing leases to the large companies that we did leases to, there was always the person that was the grower that had the expertise in the product. There was always the business person who was running the books and making sure the business was running well. And then there was the investor equity partner. And that's how all those deals went down. Because nobody has all that much cash hanging around.
So how much cash are you talking? Like 100,000, 200, 500,000?
I would think.
500?
It depends on what you're doing. On the retail side, I don't know. Because, on the retail side, what you're talking about is your lease deposit, your setup of your store, right? That kinds of things. In the warehouse buildings where they were growing, the big costs were they had to ventilate the buildings because the grow lights were so hot on the inside of the building, and the odor was so strong that they had to get all of that out of the building. So I would say that these people were investing $100 a square foot on their space in upgrading the power and upgrading the HVAC in the building. And then the other thing that we had to do is if we did one in a multi-tenant building, and they had to do a special seal at the top of that demising wall because the odor was going over the wall. So those were the major costs for the growers. On the retail, you're going to have your security deposit and whatever your TIs are going to be. So if your rent's, $1,500 a month, I would say I would be prepared to have a full year's worth of security deposit in cash.
Oh, that's fine.
Yeah. Now, security deposit or prepaid rent, whatever you want to call it, some of that can be applied to your rent down the road, but it's what you negotiate up front with that landlord. So cruising through this, most of this lease is pretty standard. Insurance, you as a tenant will bring your own insurance. So the landlord will have fire insurance on the building, you will have liability insurance, and that covers you and your employees, the use in the building, if you damage the building, it can cover your product in the building. So that's a different cost to you. So in this section, what I do with this section for my tenants is I hand it off to their insurance broker and say, you figure it out and give us the best price. I do not try and understand it because it's very complex. But the insurance broker's got it all down. And for marijuana use, it was a little bit tricky to begin with. Assignment and subletting. Sometimes the landlords will let you assign and sublet, sometimes they won't. It's something you may think about it, like if you're going to grow and I had to sign a 5-year lease, but I know in 3 years I want to move out of here, you might want to preserve that for yourself. Default. This is a section where you can read about all the different ways that you can default and what the remedies are. So, and there are remedies. They can't just come after you and take all your money without actually trying to remedy the situation. So if you go Chapter 11 and you still have 3 years left on your lease, the landlord does have an obligation to try and lease that space. So just so you know. Mortgage subordination and attornment along with estoppel certificates. This is if the landlord is selling the building and you're a tenant in the building, and he's going to come to you and let's say his lender says, hey, we want to do something, and you can explain this a lot. There's going to be forms that you're going to need to sign, and you're pre-agreeing to sign those forms. An Estoppel Agreement is basically we're selling the building, we're looking at your lease, you tenant, I want you tell me, the new buyer, that this lease is in effect and it's been performed as agreed that there's nothing that this landlord owes you, like, there's no, payment down the road that isn't in the lease that you think he owes you that I'm going to have to pay you and I'm not expecting. So that's what estoppels are. Holdover is at the end of your lease, you don't have anywhere to go and you need to stay for a little while. This tells you what it's going to cost you to hold over if the landlord will let you stay there. So the rest of this is pretty simple. Exhibits and riders, you will have a whole bunch of exhibits and riders on the back of this, from tenant improvements to addendums to the rent rider, which lays out exactly how much rent you're going to pay. Most rents go up by 3% annually on the turnover. So this is where CPI is in here. So hardly anybody's using CPI anymore because CPI is really low right now. So they'd rather just charge you a 3% increase. When CPIs are really high, then landlords are all over that. So this is basically your lease. I would say on this, when you get into a lease, it could cost you $1,500 to get an attorney to review a lease. Well worth every dime if you're getting into a lease that's going to go for a couple of years. There's things in a lease that I just pass off to an attorney because in the state of Washington, a broker is held to the same standard as an attorney, even though you don't have a law degree, right? So I could get myself in big trouble if I try and interpret some of this stuff to a tenant, especially in some of these sections can be quite complex. So this is very dry reading. You can read through it all, but then I would say spend that extra money and have an attorney review this before you sign it, because those personal guarantees can be very strong. So there you go.
One question, how do you, what's your recommendation to say for instance, some of these entrepreneurs want to get a, commercial real estate broker? I mean, what kind of things that they should look for and ask about their qualifications or whatever? Because it's all about relationships, right? So.
I would talk to somebody who's, at a commercial firm. And there are a few brokers I know that work at residential houses that do commercial and they do just fine, but you wouldn't know that going in. Some residential houses now don't allow their residential brokers to do commercial real estate. They have to refer it off. So if your friend is selling houses and yeah, she can get on the multiple and search for spaces for lease, or he, doesn't mean that they have ever done it before. And it can be kind of tricky. I would go to one of the, you can get online and you can even through Craigslist or just through the Commercial Brokers Association, you can search properties for lease and there'll be brokers assigned with that. And then I would just talk to people, interview a few people or talk to them, call them on their listing, see if you like them, see if they seem smart, if they understand what you're trying to do. Some brokers don't want to work with new companies. They'll let you know that. They'll just say, hey, I don't have anything or whatever, refer you to somebody else. But it's a relationship business and it's a relationship between you and your broker. So, and you'll know when you get along with somebody, when you're talking the same language and if they want to work with you and you want to work with them. But I would not go to your Aunt Sally that sells houses on Sundays, and it's just not the same world. Just like I would not try and sell a house. I would be no good at it.
And I had a question about on the leasing. You said if you're going to be a business or an individual, a franchise, you consider a business or personal?
A franchise is a business. What they're looking for is who's really paying the rent and who's guaranteeing the lease. So if you buy a franchise, that's your business, right? And you're buying that franchise and you are the individual with the money behind the franchise. So they're probably going to want to do the lease with you.
Okay.
Yeah. All right. Thank you, guys.